fight just took a massive turn. Imagine passing a law in your state that tells the federal government, "Stay out. We're protecting our people, our gun rights, and our Constitution." That's what Missouri did. But now, everything has changed. The Supreme Court has stepped in not quietly, not passively, but with an emergency order, an 8-1 decision that's sending shockwaves through every red state with similar laws. The Second Amendment Preservation Act, once hailed as a bold move for gun rights, is now hanging in the balance. And the federal government just got a green light to strike back hard. What happened? Why did the DOJ sue? And what does this emergency order really mean for the future of your rights? We're breaking down what the court said, what Missouri did wrong, and how this decision could reshape gun rights battles across the country. You need to hear this. Let's get into it. Section 1. Missouri's Line in the Sand. Back in 2021, Missouri passed the Second Amendment Preservation Act, or SAPA. The law declared that Missouri police were not allowed to enforce federal gun laws the state deemed unconstitutional. It was bold, it was aggressive, and it quickly became a national symbol of resistance. SAPA punished police departments with fines up to $50,000 if they helped enforce federal gun regulations. The law declared federal gun laws invalid within Missouri if they went beyond the Second Amendment. Missouri essentially told the ATF and DOJ, "Not in our state." Other red states watched closely, considering similar laws of their own. At the time, gun rights advocates praised SAPA as a model for pushing back on federal overreach. But behind the scenes, pressure was building, and the DOJ was already preparing to strike. This wasn't just a state law, it was a challenge to federal supremacy, and the feds weren't about to let it slide. Section 2. The DOJ lawsuit hits hard. In early 2022, the Department of Justice filed a direct challenge to SAPA in federal court. Their argument was simple but powerful. States cannot nullify federal law. The DOJ claimed SAPA violated the Supremacy Clause of the U.S. Constitution. They argued that Missouri was obstructing federal agents and undermining national enforcement. The lawsuit specifically cited ATF investigations that stalled because Missouri officers refused to help. Federal officials warned that public safety and constitutional order were at risk. This was more than a policy dispute. It became a constitutional showdown between state rights versus federal power. The district court ruled SAPA unconstitutional. Missouri appealed. But the battle didn't end there, and this is where the Supreme Court steps in. Section 3. The Supreme Court steps in and strikes. On a cold January day in 2024, the Supreme Court issued a surprise emergency order. It wasn't subtle, it wasn't delayed. It was an 8-1 decision, rejecting Missouri's request to keep SAPA alive during appeal. The court denied Missouri's emergency application for a stay, allowing the lower court's decision to take effect. That meant SAPA was officially blocked, and Missouri could no longer enforce its Second Amendment law. Only Justice Neil Gorsuch dissented. The rest of the court, including Thomas, Alito, Barrett, and even Kavanaugh, sided with the DOJ. It sent a clear message. The federal government is still in charge of federal law, especially when firearms are involved. This wasn't just a loss for Missouri. It was a signal to every other state with similar legislation. SCOTUS is watching, and the margin is 8-1. Section 4. Missouri's gun law just got gutted. When the Department of Justice sued Missouri over its SAPA law, they went straight for the throat. They argued Missouri wasn't just refusing to help enforce federal gun laws, they were actively punishing officers who did. That was the turning point. The federal judge agreed and blocked major parts of SAPA from being enforced. SAPA imposed $50,000 fines on officers who helped enforce federal gun laws. Local police were forced to choose between state loyalty and federal cooperation. Federal agencies argued SAPA directly interfered with their operations. Courts ruled that the law crossed the line from non-cooperation to obstruction. That ruling sent shockwaves. It wasn't just about one law, it was a message to every other state that had followed Missouri's lead. The legal system drew a hard line, and Missouri's version of gun rights enforcement got stripped down fast. Section 5. Other states are now backpedaling. Missouri wasn't the only state watching this unfold. At least 5 others, including Texas and Arkansas, had passed similar Second Amendment preservation laws. But after the Supreme Court denied Missouri's emergency appeal, those states started pulling back. Here's what's already happening. Attorneys general in other states are pausing enforcement of their own SAPA-style laws. Police unions are pressuring lawmakers not to risk lawsuits or funding. Legislatures are now rewriting their laws to avoid the same mistakes Missouri made. Federal agencies are quietly resuming partnerships with local law enforcement in those states. The momentum behind SAPA laws is fading, and without Supreme Court backup, states are realizing they don't have the power to nullify federal gun laws. That's forcing a legal reset, and it's leaving gun owners caught in the middle. Section 6. Red flag orders. Get fast-tracked in New York. New York has quietly overhauled how fast red flag orders can be filed, and the change has massive consequences for lawful gun owners. What used to take days can now happen in just hours. Here's what changed. Judges can now approve temporary red flag orders without a hearing, the same day a request is filed. Family members, teachers, and even co-workers can initiate the process. Police are encouraged to seize firearms immediately under temporary authority. The gun owner may not know about the order until the knock is at the door. That means a single argument, a vague complaint, or a misunderstanding could trigger a rapid seizure before any due process happens. And in this new model, the burden is on you to prove you're not a threat, not the other way around. Section 7. The $200 NFA tax stamp is quietly fading out. For decades, the $200 NFA tax stamp has been the price of admission for owning suppressors, short-barreled rifles, and other regulated firearms. But a quiet shift is happening, and it could redefine how these items are classified. Here's what we're seeing. Several federal bills are pushing to remove suppressors from the NFA entirely. ATF processing delays have pushed lawmakers to simplify the system. Some states are now waiving local tax requirements for NFA items. There's legal precedent building that excessive tax barriers may violate the Second Amendment. But here's the trap. Even if the tax goes away, registration doesn't. And failure to follow those rules, even by mistake, still brings serious felony charges. So, while it looks like freedom on the surface, the strings are still very much attached. Section 8. Colorado's new training trap. If you live in Colorado or ever plan to carry there, you're now facing a brand new obstacle. Starting in 2026, the state is enforcing strict new rules around who qualifies for a concealed carry permit. And it's not just about training, it's about control. All applicants must attend a state-certified in-person class. Online training is banned, regardless of quality or experience. Military or law enforcement experience no longer exempts you. The course includes legal instruction, safety, and de-escalation. No training certificate means you're automatically disqualified. On the surface, it looks like common sense, but beneath it, this law sets a powerful precedent. By forcing all training into state hands, Colorado is testing how far a government can go in restricting carry rights without banning them outright. Other states are watching closely, and many may follow next. Section 9. Retroactive gun bans are quietly spreading. Imagine waking up and discovering that a gun you bought legally years ago is suddenly illegal. No crime, no warning. Just a new law that turns you into a criminal overnight. That's exactly what's unfolding right now in several states. Illinois, New York, and California are introducing retroactive bans. These laws apply to guns and magazines you already legally own. Some offer no grandfathering, no registry, just confiscation. Voluntary buyback programs carry real criminal penalties. Local police are being authorized to seize banned items on site. This is not just legislation, it's a test of how far the government can reach back in time. If courts allow it, other blue states could erase decades of lawful ownership with a single vote. The Second Amendment doesn't expire, but these bans are betting you won't fight back. Section 10. Carrying a gun could justify a search. There's a dangerous legal shift happening in real time. In some courts, simply carrying a gun even legally is being used as justification for police to search you. You may be licensed, trained, and fully within your rights, but that might not stop a search if an officer claims they're concerned for their safety. Federal courts are now treating lawful gun carry as a potential threat factor. Police are allowed to prolong traffic stops based on firearm suspicion alone. This suspicion can lead to full vehicle searches, pat-downs, or temporary detention. Some rulings say officer safety outweighs your right to be free from unreasonable search. In effect, the lawful act of carrying can be treated like criminal behavior. This isn't just about bad policing. It's about courts rewriting how the Constitution works in real life. If carrying a gun makes you automatically suspicious, then every permit holder is just one step away from being searched or worse. The Second Amendment gives you the right to carry, but this new trend could erase your Fourth Amendment protections the moment you do. Know before you're caught. All of these changes share one dangerous thing in common. They target the average responsible gun owner. Not criminals, not gangs, but everyday people who are trying to stay legal. A training requirement here? A procedural shortcut there. A redefinition of consent in a traffic stop. Piece by piece, the rules are being rewritten in ways that make it easier for you to slip up and much harder to defend yourself when you do. But now you know, and knowledge is your best weapon. So use it, share it, and stay alert. because 2026 isn't just another election year. It's the year gun laws change beneath your feet. If this helped you, subscribe. This channel is here to keep your rights protected, your family safe, and your voice informed when it matters most.